Hey guys, consider me your ultimate study buddy today. We're going to completely lock in everything you need to know about the Hindu Minority and Guardianship Act of 1956. We're taking this dense legal text and turning it into a high-yield, perfectly structured exam recap tool. Seriously, the HMGA is wonderfully short, literally just 13 sections, but it is packed with strict hierarchies, absolute restrictions, and major exam traps. So block out the distractions, focus up, and let's master this 13-section cheat sheet together.
Okay, let's dive right into our mental roadmap for this exam recap. We'll be hitting 1, the HMGA basics, 2, identifying natural guardians, 3, powers and critical restrictions, 4, testamentary and de facto rules, and finally number 5, the paramount guiding principle. All right, jumping into section 1, the HMGA basics, application and definitions. We're going straight to the source here to decode this act, kicking things off with sections 1 through 3. These initial sections establish the absolute ground rules. The act applies to Hindus and covers the whole of India. But here is the crucial takeaway for your exam. The HMGA is purely supplementary to the Guardians and Wards Act of 1890. It doesn't replace the older law at all, it works right alongside it. Moving on to Section 4, let's do some rapid-fire definitions to lock in the baseline of this act. First up, a minor. Under the HMGA, a minor is simply any person below 18 years of age. Super straightforward. Just burn that into your memory. Next up in Section 4, what exactly is a guardian? Well, it's defined as a person having care of the person of a minor or their property or both. And keep in mind, this is a broad umbrella term. It includes natural guardians, guardians appointed through a will, meaning by the kid's mom or dad, a court-appointed guardian, or even someone empowered under a specific act. Rounding out our basics is Section 5, and this one is a real game changer. Section 5 gives this act an overriding effect. Basically, this means the HMGA overrides older Hindu law customs or texts that deal with guardianship, unless a specific custom is expressly saved by the act itself. So if there's ever a conflict between an old custom and this 1956 act, the act wins, period. Let's move to Section 2, identifying natural guardians, the hierarchy. Now, examiners absolutely love to test your memory on this exact sequence. So let's break it down. For a boy or unmarried girl, the natural guardian is the father, and after him, the mother. But watch how it flips for an illegitimate child. The mother is first in line, then the father. If we're talking about a married minor girl, the natural guardian becomes her husband. And just briefly jumping to Section 7, for an adopted son, the hierarchy is the adoptive father first, followed by the adoptive mother. But wait, there is a massive exception to that very first rule you just memorized, and they will definitely test you on this. While the father is generally the natural guardian for a boy or unmarried girl, Section 6 loudly pivots and states that the custody of a minor who hasn't completed the age of 5 years shall ordinarily be with the mother. This under 5 exception is a classic exam focal point, so underline that in your brain. You also absolutely need to know who cannot be a natural guardian. Section 6 lays out some strict disqualifications. First off, the terms father and mother strictly exclude step-parents. Step-parents do not get natural guardian status here, no matter what. Plus, a person completely loses their right to be a natural guardian if they cease to be a Hindu, or if they completely renounce the world, like, say, becoming a sannyasi. Because, let's be real, it's pretty hard to manage a minor's estate from a secluded cave in the Himalayas. These are classic standard exam traps just waiting to trip you up. That wraps up the core of Sections 6 and 7, which brings us to the ultimate heavy hitter of this entire law. This next part is where the bulk of the exam points are hiding. Section 8. Let's get right into it. Section 3. Powers and critical restrictions. Consider yourself heavily warned on this one. Let's break down exactly what a guardian can and cannot do under Section 8. On the plus side, a natural guardian has the power to do all acts that are necessary, reasonable, and proper for the benefit of the minor or for the protection and benefit of their estate. It's a broad, empowering rule, but it comes with an absolute restriction right next to it. The guardian can, in no case, bind the minor by a personal covenant. Simply put, they cannot enter into a contract that makes the kid personally liable. So the crucial point here is that for major property transactions, the guardian's hands are totally tied unless they get prior permission from the court. You'll need to memorize this exact list for the test. Without court permission, a natural guardian cannot mortgage, charge, sell, gift, or exchange any part of the minor's immovable property. Oh, and they also can't lease the property for a term exceeding 5 years or for a term extending more than 1 year beyond the date the minor actually reaches majority. And here is your giant red flag vocabulary word for the exam: voidable. If a guardian ignores Section 8 and, say, sells off property without that required court permission, the transaction isn't automatically void. No, it is voidable at the instance of the minor. This means that when the minor comes of age, they hold the legal power to challenge and completely undo that transaction if they want to. Moving into Section 4, Testamentary and De facto Rules. We're entering the final stretch of our recap now, tackling Sections 9 through 13. We're going to look at the rules for guardians appointed by will, the incompetence of minors, and a very specific rule regarding copersonary property. Let's look at Section 9, which gives us a very specific step-by-step flow for testamentary guardians, meaning those appointed by a will. Step 1, a Hindu father can appoint a guardian for his legitimate children through his will. But Step 2, if the mother survives him, the father's appointment has no effect whatsoever, and the mother gets the power to appoint a guardian through her own will, which prevails. Then, Step 3, if the mother dies later and fails to appoint someone in her will, the father's original will revives and actually comes back into force. Oh, and a quick side note. For an illegitimate child, the mother is the one who holds the power to appoint the guardian by will from the start. Now for some rapid-fire, high-yield trivia for Sections 10, 11, and 12. Section 10 is super simple. A minor is completely incompetent to act as a guardian for another minor's property. Easy. Section 11 is a massive red flag. A de facto guardian, meaning someone who has assumed guardianship in practice but has no actual lawful authority, is absolutely not entitled to dispose of or deal with a minor's property. Hands off. Finally, Section 12 dictates that if a minor has an undivided interest in joint family copersonary property and that property is being managed by an adult member of the family, a standard court will not appoint a guardian for it. Only a high court retains the inherent jurisdiction to step in there. And that brings us to Section 5. The paramount guiding principle. Section 13 explicitly states welfare of child of paramount consideration. This brilliantly illustrates the entire heart of the legislation. The rule here is crystal clear. Absolutely no person shall be entitled to act as a guardian if the court feels it is not for the benefit or welfare of the child. You really have to think of Section 13 as the ultimate trump card or the final veto. Look, you just spent all this time memorizing the strict natural guardian hierarchies in Section 6, father first, then mother. But if a judge determines that giving guardianship to the father is not in the paramount welfare of the minor, Section 13 overrides that hierarchy completely. The welfare of the minor beats every single structural rule we've talked about today. So as we wrap up this exam recap, I want to leave you with a final thought to take back to your studying. When you're sitting in that exam room reading a complex fact pattern, ask yourself, how does Section 13's paramount consideration change the way you argue any of the previous 12 sections? Because if you can dynamically apply that ultimate veto rule to the strict hierarchies and powers we just learned, you aren't just going to pass this test, you're going to completely ace it. Thanks for jumping into this study session with me today, and good luck out there.